Wonderful to be on Larrakia country. It's fitting for this event to be held on the country of a people who've contributed so much to the ongoing objective of just and equitable treatment and recognition for First Nations people of this country. My deep respects to all Larrakia ancestors and to their elders whose leadership, determination and custodianship has inspired many. And a warm welcome to colleagues, members of the profession, representatives of First Nations organisations and communities, and distinguished guests joining us in person and online. And a very happy NAIDOC week to everyone. What a significant coincidence that the Federal Court shares a 50th anniversary with NAIDOC week. The legislation establishing this court was passed at the end of 1976, so 1976 was a momentous year. This seminar forms part of the Federal Court's 50th anniversary National Practice Area Seminar Series. The seminar series is the start of our celebrations of our court's 50th anniversary, and it provides an opportunity to reflect on those areas of practice that have shaped our court's work and continue to influence its future. When this court was established, it had no native title jurisdiction. There was no native title law as such. Malurpin and Nabalco had been decided right here in Darwin only 5 years before this court was established, with the lead plaintiff being a Rurutingu man. The other plaintiffs were Gumatj and Japu men. In 1976, when this court was established, the Mabo No. 1 decision was more than 10 years away, and Mabo No. 2 was more than 15 years away. Since 1993, this court's native title jurisdiction has held a unique and significant place in the work of this court. Our judges, registrars and court staff all know the privilege of doing this work, and our court has collectively worked hard to develop innovative ways of discharging our judicial function in this jurisdiction. And you'll hear a little bit more about that this afternoon. For this event in particular, I thank all the team at the Federal Court for their coordination, and particularly our Federal Court staff here in Darwin. And a big thanks to our two National Native Title Coordinating Judges, Justice Michael O'Brien, who's here, and Justice Erin Longbottom, who isn't able to join us today. But we are very fortunate to have another colleague who recently decided one of the most important native title compensation decisions of recent years, Justice Katrina Banks-Smith. And I'll leave Katrina to introduce our very distinguished panel who's sitting down at the bar table. But now I'm especially pleased to welcome Mr. James Parfitt of the Larrakia people, who will deliver a welcome to country. And we're very grateful to James for joining us today. Thank you.
Thank you, Judge. I first off want to say Bachiwa Garamilla, Darabanangalinya, guide and watch over you while you're here. It's just an informal way of saying g'day and welcome. Good afternoon, distinguished guests, honourable judges, elders and colleagues. My name is James Parfitt from the Fiji clan, and it's a great honour to welcome you all here today. I'd also like to acknowledge everyone and welcome everyone. So no matter wherever your roots may come from, no matter about race, colour, creed or religion, welcome to this beautiful country. Larrakia Nation, just like all other First Nations people of this land, has never given up or ceded our lands. And this land we're on this afternoon always was and always will be Larrakia land first. Traditionally, when people from other places visit Aboriginal country, a traditional owner would ask to welcome them to their country, and a welcome to country was given. This meant that visitors would be given safe passage through our lands. And we do this simply because we come from a culture of caring and sharing, and this defines who we are as a First Nations people. I extend that respect to all Aboriginal and Torres Strait Islander people here today and online. Today is a moment of deep significance. We gather to mark the 50th anniversary of the Federal Court of Australia, an institution that has played a profound role in shaping the legal landscape of this nation. At the same time, as the judge said, we're celebrating 50 years of NAIDOC, a movement grounded in truth, justice, and the voices of Aboriginal and Torres Strait Islander people. These two anniversaries sit side by side in a powerful way, because over the last 50 years, we have seen a transformation in how Australian law begins to recognise what has always been known by Aboriginal people, that country is not just land, it is our law, it is our identity, it is us itself. In that time, we have witnessed historic movements in native title, as the judge says, the Mabo decision, the establishment of the Native Title Act, creating a framework for recognition and protection of rights and interest in lands and waters. The Wick decision affirmed that native title could coexist with pastoral leases, and countless determinations since, each one more than a legal outcome, but a recognition of truth, a recognition of survival, and recognition of continuity. For Aboriginal people, these achievements are deeply significant. They're not just legal milestones, they are an acknowledgement of who we are and where we have come from. They affirm that our law, our stories, and our responsibilities to country have never been extinguished. They create pathways for heading, for truth-telling, for respect, and for a more just future. But they also remind us that this journey is ongoing, because recognition alone is not enough. It must be matched with respect, partnership, and genuine listening. This is why gatherings like the Federal Court Judges Forum and the Native Title Conference are so important. They represent a continued commitment, understanding to improving the systems and ensuring the justice of this country reflects the deep and strength of the oldest living culture of this earth. I'd also like to take a moment to share something personal. Many years ago, I had the privilege of working within the Federal Court of Australia in Sydney, just around the corner from Martin Place. Coming from Darwin, from community, it was a young man stepping into what felt like the big smoke. But what stayed with me was not the scale of the city, it was the way I was treated in that institution. I was welcomed, I was respected, but most importantly, I was treated as an equal. That hasn't always happened to me in my professional career. And that's something that I'll remember to the day I die, the way I was treated in this great institution. But that experience left a lasting impression on me, one that I carry with gratitude to this day. And I would acknowledge and thank the people of the Federal Court for that spirit of inclusion, because it matters. And it shows what is possible when institutions create spaces where people feel they belong, just as it did with me. As we reflect on these two 50-year milestones, NAIDOC and the Federal Court, we are reminded of both progress and responsibility. Progress is how far we have come, but always how far we have to go as a nation, especially in these difficult times when we have a responsibility for where we must go. Let us continue to walk together, grounded in truth, guided by respect, and committed to justice for all. Before I go, I just want to finish on one story. A story that has stayed with me for many years, not because of its constitutional importance, not because it reshaped the nation, but it's because it completely changed the way I look at milk. Yes, milk. Now, when most people think about the Federal Court, they think of serious matters, native title, corporations law, complex litigation, and they're absolutely right. But what I didn't expect when I was a young man from Darwin arriving in Sydney was to sit through a 3 to 4 day legal argument about milk in the Federal Court of Australia. That's right, milk. Not illegal substances, not international disputes, milk. Not just any milk, this was a deep forensic, highly technical examination into the legal differences between homogenised milk and pasteurised milk. Remember, this is 4 days. Now, where I come from, you've got a pretty simple legal framework around milk. You open the fridge, you smell it, you make a decision. That's the law from my mother. But in the Federal Court, things are a bit more sophisticated. Day one, I'm sitting there thinking, all right, this is interesting, we're warming up. Surely this is just the introduction. Day two, we're still going. Day 3, charts come out, charts for milk. By day 4, I'm no longer a spectator, I'm emotionally invested. I've actually picked a side. And I'm sitting there thinking in my head, never out aloud to the judge, Your Honour, with the greatest respect, I don't just think milk has been sufficiently homogenised. You had barristers, some of the sharpest legal minds in this country, standing there in full robes, speaking with absolute confidence about fat distribution, heat treatment, molecular behaviour. I thought this was incredible. Back home, if milk starts getting too technical, we just call it off. At one point, I generally felt like the milk had better legal representation than most of my people. And what really struck me was the seriousness of it all. No one was laughing. No one was saying, are we really here? Again, talking about milk? No. This was handled with the full dignitary of the court. Submissions were made, authorities were cited, arguments were tested. I'm fairly sure at one point someone almost cross-examined the carden. And I remember thinking, if you walked in off the street, you'd assume that this was a matter of national importance. And at that moment, it absolutely was. Because to the people involved, the industry, the standards, the livelihood, it mattered to them. But I'll be honest, for 4 days of this, I walked out with two things: a deep respect for the legal system and a suspicion of milk I've never quite shaken. To this day, I don't just drink milk anymore. I look at it carefully, like I know what you're hiding. And now when I go to the shops and see the different types of full cream milk, light, skim cream, I don't see products anymore. I see potential litigation. But in all seriousness, that experience taught me something very important. Remember, I was down in the big smoke. That law has the ability to take something completely ordinary and examine it with such depth, care, and seriousness that you realise nothing is ever just simple, not even milk. So when people ask me what it was like working at the federal court, I tell them I saw justice in action, I saw respect in action, and I saw people being heard. And I saw 4 days of legal argument that proved beyond reasonable doubt that milk is very, very complicated. Now, while I can smile about those 4 days of legal argument over milk, it brings me back to something far more serious: native title. Because when it comes to native title, we're not just talking about something ordinary. We're talking about our country, for my people, for the Larrakia and Warramunga people, and nations of the Northern Territory. Country is not just land on a map. It is our law, our identity, and our ancestors, and our future. It holds our stories, it carries our responsibility, it is where we come from, and where we will always belong. So getting native title right truly matters, not just for us, but for every single generation that comes after me. My bloodline, my children, and their children, and their children, for the next 60,000 years. Because when it's done properly, it doesn't just recognise rights, it recognises truth. Truth of our connection has never been broken. Truth that our law has always been here. And that recognition, it goes to the heart of who we are as Aboriginal people. Not as a concept, not as a case, but as a living connection of people to country. And the professional of my soul in that milk case just shows you the deep insight of what happens in a native title matter. Whether it's this or whether it's that, the full effort, the full concentration, and the full working heart and commitment goes into the native title. And it just shows you, I saw one little bit in action, and I've seen the big one in action. So thank you, and I'd like to finish with the words of my late and great Dadaba, Reverend Wally Fijo. You have come by way of Larrakia land. While you're here, you'll hear the voices of our ancestors. When you leave, you'll take the Larrakia message with you. It is my honour and privilege to welcome each and every one of you here this afternoon. And may our ancestors guide and protect you always. Again, welcome and thank you for this afternoon. Thank you, Joe.
Thank you, Mr. Parfitt and Chief Justice. At the centre of the court's native title jurisdiction are the applicant groups who have pursued their claims for recognition of their native title rights. Working with them are the bodies that provide native title services and legal services and work closely on their behalf with the states and territories. Our first guest, Mr. Kevin Smith, has had personal experience at every step of this path to recognition. Kevin is President of the National Native Title Tribunal and the first First Nations person to hold this position. He is a Torres Strait Islander man with traditional connections to Ugar and Errab. Prior to his appointment, he served as Chief Executive Officer of Queensland South Native Title Services, the National Secretariat of Torres Strait Islander Organisations, and the Brisbane Aboriginal and Torres Strait Islander Legal Service. If you turn to the groundbreaking native title cases from early this century, you will see Michael Barker's name as senior counsel. Later, you will see his deep commitment to native title issues reflected in the many cases over which he presided as a judge of this court, including seminal cases such as Banjima people in Western Australia. His judgments are more than just legal precedent. They record part of the history and culture of Aboriginal and Torres Strait Islander people across Australia. Michael has also served as a judge of the Supreme Court of Western Australia and was president of the Western Australian State Administrative Tribunal. Similarly, the contribution of anthropologists in gathering and testing historic evidence for use by the court is a vital part of our jurisprudence. You will see the work of Dr. Kingsley Palmer, cited regularly in the judgments of this court. Kingsley is a consultant anthropologist specialising in native title. He has conducted extensive research across rural and remote Australia and has been an expert witness in many cases, including the recent Yinjibarndi compensation case. He has published widely on anthropology within native title law. But before we turn to our conversation with our esteemed guests, we have a short video to share with you of an interview with the Honourable Michael Black, ACKC, who was Chief Justice of this court at the time of the enactment of the Native Title Act, and so had the challenge of overseeing the introduction of its jurisdiction.
Period of profound legal and cultural change. Today, I am pleased to be speaking to the Honourable Michael Black, ACKC, who served as the Chief Justice of the Federal Court from 1991 to 2010. During those formative years of native title jurisprudence, Chief Justice Michael Black played a central role in shaping and guiding the court through some of its earliest and most complex native title cases that follow the enactment of the Native Title Act 1993. He is particularly recognised for supporting procedural innovation, including the development of on-country hearings, which enhance the court's engagement with Aboriginal and Torres Strait Islander claimants and improved the administration of justice in native title matters. Well, welcome. In 1992, the High Court handed down Mabo No. 2 and then the Native Title Act is enacted in 1993.
Yes.
It was clear that the Federal Court was going to play a very important part in regards to native title litigation. Can you just describe what it was like to be Chief Justice of the court at that time and how the court initially reacted?
It was, it was challenging and exciting. It actually fitted with the culture of the court as I recall it at that time. I'd only been chief for 2 years. I recall being contacted as Chief Justice about resources for the new jurisdiction. I don't know whether we realised at the time just how resource intensive it was. It was just get on with it.
Do you have any reflections on the legal profession and how it embraced on-country hearings?
I've got a CD somewhere that says preparation for giving evidence in on-country hearings. And that was distributed. The court made its information widely available. you could see people objecting, and I think there's a case of Justice O'Loughlin saying, no, come on, this is what we're going to do. You're going to have to get in your four-wheel drive and come out here.
In terms of some of those challenges that lead to the reason why native title litigation can be resource intensive, obviously, to hold an on-country hearing, particularly in remote parts, involve complicated logistics.
Absolutely. Having a court hearing that has to be done according to law, has to be recorded, and it's hundreds of kilometres away from the nearest electricity plug. It's in country that has no name given it to other than its Indigenous name. To have a hearing so remote that is going to go not just for one day, but maybe several, you've got to have tables, you've got to have generators, transcription material, canopies, which could blow away and sometimes did. And then, of course, there was getting there. There were also cultural challenges, differences that needed to be understood and accommodated with appropriate tact and sensitivity. And also, you've got to understand the authority. Not easy. It's entirely different to anything that the courts had done.
In your view, what were the key benefits of on-country hearings for the administration of justice in native title
I don't
cases?
think it could have been done without it. I think the achievement of the court was to understand that this is not Magna Carta, Act of Settlement. The evidence is country. This is a different type of law, deeply embedded in hundreds, thousands of years of tradition, and revealed only through custom and practice.
How do you view that more generally as a significant development in the history of the court?
It's a fundamental development in the history of the court and in the history of Australian law. It really goes deep. I'm not the one who should be proud of it. The people who should be proud of it are people who organised it and the judges who sat out there for weeks at a time sometimes. But I do share a little bit of the pride because I think it was part of what we were about.
Oh.
And it's part of what Australia is and what rule of law is in our country, which is a treasure.
The Native Title Act came into force on 1 January 1994 with the object of establishing a special procedure for the just and proper ascertainment of native title rights and interests, and which would ensure that, if possible, this is done by conciliation and, if not, in a manner that has due regard to their unique character. Kevin, more than 30 years on, what has the special procedure achieved?
Thank you, Judge. Firstly, I want to, you're taught from a very young age that when you're not on your own traditional country, you're always on someone else's. So I want to acknowledge Larrakia people and acknowledge the very warm and humorous welcome and words by Brother James, as well as the Chief Justice. I think the way that I'm going to answer this question is via some PowerPoint presentations, because I think when you see the statistics over the duration of the past 30 odd years of native title, it tells its own tale. And yes, it's quantitative in nature, and the qualitative journey is hopefully we'll unpack over the next little while. But I think the presentation just shows just the numbers. So I might just stand up because I don't have one of those flash laser things, and it might be just interesting for me to point to certain things. So I don't actually have a clicker, so I'm going to ask our assistants over here to go to the next slide, please. And for those people who are online, I apologise right up front for...
Kevin, can you leave it in there?
Oh, okay.
Just so people online can...
Okay. Well, okay, I will project my voice then. This slide shows the 30-odd years of native title. So starting with the Mabo No. 2 judgment, but the Native Title Act came into force on the 1st of January. And it's interesting because you can see over the first 15 to 16 years of native title that of the claims that were brought in the federal court, the disposition rate, you could say, is hasn't moved terribly far compared to the 16 years that followed. And I just wanted to briefly make some comments about that first 16 years because I think it reflects a nascent jurisprudence. So we had a series of judgments in this court as well as the High Court that needed to explain and expand upon the jurisprudence, and that took a little while to get moving along. There's also a very political dynamic to native title, and people who will recall when the Mabo No. 2 judgment was handed down, and then the political debates around the setting up of the Native Title Act. That was one of the longest parliamentary debates in history. Shows the political nature of the kind of work that we're dealing with. And you would anticipate it to be political because we're dealing with something that really did shake the foundations of this country, where it started, the rejection of the concept, the legal fiction of terra nullius. So it was going to have a political dimension to it. I also want to make some comments around, in this first 15-year period, the Act was initially intended for most of the work to be dealt with the National Native Title Tribunal. And very early in the piece, there was the Brandy and Heriot case was handed down by the High Court, and it became fairly clear that there would have to be some institutional rearrangements there. But over this first 16 period, there was, I would say, some misalignments with the way that the tribunal was conducted itself and the court. And you can see over that period that there may have been some tensions, but I think what has happened is that in some of the realignments and the changes in those arrangements, you can see when the federal court took a very active case management approach to the disposition of native title, you start seeing a change in the disposition of native title following that period. So that map, that line graph shows that almost every 5 years there's an actual disposition of about 100 claims. So at the top there, so this is almost up to date, 1st of July 2026. So we've got, if you go to the next slide, so that shows the trajectory. This is actually showing, I mean, and James spoke about, it's just not, law and custom is just not things on a map, but regrettably, at times we actually have to reduce these things to maps, and the tribunal actually does capture this data through our registers. And you can see that over the duration of the Native Title Act, where you see the green, it says that native title exists either wholly or partly, and the figure there says 745. And then in brown, there is where native title does not exist. Now, that could be by virtue of non-claimant applications, but also there may have been decisions where there's been a finding that native title does not exist. What is interesting in the statistic, and it goes back to the question around the role of conciliation and agreement making, is that the bulk of this, the work, so there's something like 55% of the land mass of Australia is covered by a determination, and of that 55%, 46% of that is a positive determination. And if you just go to the next slide, what I'm going to do is just whip through all the applications. So there's claimant applications, revision applications, compensation applications, and then I want to talk a little bit about agreement. So this revision application, obviously under the Native Title Act, a determination can be the subject of a revision application, and the statistics show that there have already been 16 determinations where a native title determination has been revised. we could assume moving forward that that number will increase, subject to events that might occur. I might just go to the next slide, and I am conscious of time. We're obviously going to be talking a lot about compensation, I think, over the course of this presentation, but this map shows just where the number of determinations have been. And Yinjibanji, I know that it shows it as an application, but obviously there's a judgment in place there. So the takeaway from this is that where you saw the number of determined areas, you can see that it's a very nascent area of jurisprudence. We've got a very small number of cases that have been before the court and have also been resolved by judgment. And it's reasonable to assume that where you have native title, that there may very well be compensations in the future. And I think it's important to actually get that context. Might go to the next one. A lot of the agreements, a lot of native title, and this is the point that I wanted to make earlier, is that a good number of the claims that have been resolved by agreement. So 90-odd% of the claims are resolved by agreement. But associated with those determinations, there will often be Indigenous land use agreements. So how the rights and interests are applied on the ground, and obviously the federal court will make a determination around 225, but how those laws and how those rights and interests interface on the ground is often unpacked for people via Indigenous land use agreements. And clearly where you have registered rights, there's also a number of future act agreements, and I'll talk a little bit about that in a tick. But clearly the large amount of Australia is subject to determinations by consent and also via Indigenous land use agreements. And I'll just go to this. So I just thought I'd put this slide in because the grey area is the important area. So it shows where the work might arise. So in the past, we've had historical claims that have been withdrawn for whatever reason. It could have been that there's been the need to actually focus on core country claims and withdraw claims. There's a lot of sea country claims that have been withdrawn over the time. It is only a matter of course that people will want to consolidate their country and pursue their sea country claims. So you can see from there's currently 133 native title claims in the system before the federal court, but you can assume that there's going to be additional claims where the historical claims were in the past. So there's a little way to go, I think, on this very important story. Next slide. And I just wanted to add this final slide. So in native title, the body that holds native title on behalf of the native title holders will be what's called a registered native title body corporate. We just call that a even shorter term PBC, prescribed body corporate. And I just wanted to put this slide in because there's currently 294 PBCs, RNTBCs in the system. By the time that we reach the final stage of the first phase, it's reasonable to assume that that number of corporations, PBCs, would be over the 300, maybe into the 320, 330. And these institutions are going to be a really important part of how native title and compensation is going to be prosecuted in the future. So I just wanted to, I know that there's a lot of information in there, but I just think a picture can paint 1,000 words, and there are my 10,000 words. So thank you.
Thank you, Kevin. Now we're going to turn to Michael and Kingsley and really talk about their experiences with some of the early on-country matters. Michael, you've been involved since the inception. You were senior counsel for the Murruwong-Gadgerong claimants in Western Australia and Ward, so the first native title claim that actually was heard and determined under the Act. Can you talk to us a bit about what it was like being involved in that matter and some of the practices that you put in place to deal with some of the cultural sensitivities and the matters that sort of became a template for how we deal with native title hearings going forward?
Thank you very much. The trial started taking in Keep River in the Northern Territory and going across to Kununurra, going up to Wyndham and going down to the Argyle diamond mine, Murruwong country, Gadgerong country in the north. It was a smaller area. just coming up, what's that, 30 years ago. Seems like yesterday. I've given Marcus Solomon a little handbook and said, pass it around because it's got a few snapshots from the time. Just pass it around, have a look at it when it comes by you. The things that Michael Black said about on-country hearings resonated with everybody. On-country hearings had been pioneered under the Aboriginal Land Rights Act here in the Territory, the 1976 Act. Justice John Toohey, with his assistant anthropologist Ken Maddock, went out on country. I think Finnis River was the first. And they pioneered on-country hearings. They pioneered how to make the tents and the canopies and, you know, the bough sheds that we needed to go places. And we went before Justice Lee, who was our trial judge. We made the proposition that this case had to be heard on country. We were lucky we had an excellent judge who understood more than the average judge. And he accepted our proposal to go out on country. And the Mirrabong and Gadgerong people, through their organisations in Kununurra, came to the party. People were making the lunches, they were going out and setting up at the various places we went to. And without that, as Michael Black said, there wouldn't have been relevant evidence. Aboriginal people that I was dealing with, their usual connections with a court, something called a court, were not particularly happy ones. If it wasn't them, it might often be their children, their grandkids who'd been to court but finished up in a jail. And the further idea that you would sit in a building and take evidence was nearly impossible to imagine. When I met with my clients out at the kitchen at the back of, as it was called, out the back of Kununurra, we sat on the ground. Well, many of the people did. I sat on a chair. I was learning Aboriginal cultural practices each day and being lectured in that process. So we started, and it became very clear to me that the only way you could portray the evidence in its full Technicolor living colour was to be on country. The very first evidence we took was from a woman called Daisy Birui, a very old lady, who it was said her father was the king of the Ord River from way up near the Diamond Mine all the way down to about Kununurra. We took the evidence at what's called the top dam. I don't think Daisy had ever sat in a chair. She just did all of her business sitting on the ground, and that's where I started off, taking her evidence. And that's where it went from. There was one day, and there's a lovely picture of Sheba Dignari in the handbook that you've got, and we were just out of the Keep River area. Gurundalm was the name of the Mirrabong place, and it was a dreaming for the Brolga. And we were up high and looking across to it. And I said to Sheba, could you tell the judge about that place over there? And she said, that's Gurundalm. And I said, is that an important place? And she said, yes, it is. In the Narankani, the time when the earth was soft, that's where this creature came through. And it formed all of that country. It made that country. And that's that Brolga now, mummied, turned to stone in that hill. Now that's evidence that you don't ordinarily get in any sort of proceeding, but if you're dealing with native title, it's all about what native title is. It's a living culture. Sheba could never have given that evidence, I don't think, just sitting dryly in a hall or a courthouse in Kununurra, worse still in Perth in the federal court. And it just turned it into, this is what native title is. If you want to understand the Narankani, there it is. I've never heard a better description in all my time. The anthropologists can tell you all about it, and they're important people, Kingsley, and we'll talk about you and them. But that's why we did native title hearings on country, so that people were not intimidated by the surroundings. They felt comfortable. They're talking about their own country, and that's it there now. It's mummied. Just beautiful. That's why we did it, Katrina.
Thank you, Michael.
Thank you, Michael. I'm going to turn the topic of how to capture evidence in the field, as Michael's been speaking about, and speak a little bit about anthropology, and direct a question to Dr. Kingsley Palmer. Kingsley, you've had over 50 years of experience in the field of First Nations anthropology, having commenced research and field work in the early 1970s. What are some of your reflections on the role of the anthropologist and how that's changed since the inception of the Native Title Act?
Yes, thank you. The relationship that anthropology has had with legal process, of course, goes back way beyond the inception of the Native Title Act. But it's marked, in my experience, by a special relationship. Not only the special relationship which anthropologists have with those First Nations people with whom we work, but also with the legal profession, both as solicitors, barristers, as well as with the federal court itself. And that has had a profound effect on the way in which anthropologists have developed their discipline over time in relation to these activities. My personal view is that one of the consequences of this is that anthropology has emerged as something which can actually be useful. And yes, I thought some of you might smile at that, because that also was one of the changes which developed and indeed caused some consternation initially, which still hangs about between those of us who practice in what is sometimes called an applied field and those who practice in the academy. The criticism being that those of us who are in the latter category may have lost our independence and our freedom of intellectual inquiry. I refute that, of course, because of my experience. I think that, for me certainly, being involved in the native title process has improved the kinds of anthropology we do, because we can no longer, as one of my colleagues put it some years ago now, just rely on fancy footwork. We all soon learnt that fancy footwork didn't cut the mustard when it came to the federal court, and indeed before that under the Land Commissioner in the Aboriginal Land Rights Act hearings. This meant that in terms of what the opinions that we were going to give had to be founded clearly upon something which could be represented and reproduced in the court and give our opinions weight that could be duly considered in the court. There are a lot of other changes which occurred in the Act, but I think that might do.
Thank you, Kingsley. I wonder if we might move to agreement making. Michael, what do you think?
Yes, certainly. Earlier in one of my questions, I read a section of the preamble to the Native Title Act, and indeed the title to this presentation we're giving today is based on that statement in the preamble to the Act, that a special procedure needs to be available for the just and proper ascertainment of native title rights and interests, which will ensure that, if possible, this is done by conciliation. One of the special procedures available under the Native Title Act is the power conferred on the court to make a determination based on an agreement between the parties to the proceeding. And that's between the applicant, the relevant state or territory, and usually the Commonwealth, and frequently other interested parties. Kevin, can I ask you, you've had involvement in the process of consent determinations, both as a former CEO of a representative body, the Queensland South Native Title Services Limited, and as well as a native title claimant. Do you think that the Act has had success in facilitating the recognition of native title by conciliation and by agreement?
Thank you. Look, I think the statistics bore out that agreement making is critical to achieving native title. We have to remember that, as James said in his introduction, before the Native Title Act, we were legally invisible, and to actually bring together a statute that actually was around the fair resolution of matters that dealt with hitherto unprecedented matters. It had to have a process where it built on strong conciliation between the parties, a facilitation process, and by agreement making. We have to remember that native title is not one of those classic disputes where people may have a particular, they've got an existing relationship and there could be tension and it's brought before a court or a tribunal to work through those issues. In this particular area, you may have parties that have never met each other, and it's the bringing together of the relationships of the different rights that coexist over that area, and that is difficult to do via a pure litigious process, because if you don't know, if you don't have an existing relationship, you don't know how those rights interact with each other, then there needs to be a process to navigate that complexity. And conciliation brings it out. And I have to say that there is really, there is a power differential. Here you have Indigenous peoples who are the most, and the preamble says this, the most disadvantaged by virtue of the process of colonisation. They have the burden of proof, and you have a myriad of other parties that have got, you know, whether it's a state government or a mining company or a pastoralist, you've got, there's a really big power differential. So having a conciliation that can actually at least ameliorate the impacts of that power imbalance, of that asymmetrical relationship is important. But also, as I said in my earlier comments, a bare determination under 225 is not going to tell the parties or direct the parties how the rights are going to be implemented on the ground. And so having agency and the parties working through those issues, not only to resolve the claim, but how are we going to implement the rights that coexist after the determination is made, is really critical. So agreement making it's a fundamental tenet of the Native Title Act. It's whether it's in my capacity as a representative body CEO, we use the dispute resolution function when we were working out matters between overlapping claim groups, whether it be with the tribunal at the moment, with in the Future Act regime, and the federal court, the way that it deals with a court-ordered mediation. So those tools in the toolbox are critical to resolving these issues. So, yeah, look, I think it's, and from a native title holder's perspective, we were able to secure a native title outcome that was difficult to secure, but when we got there, it was actually something that that was really quite cherished by all of us. And I have to say this, and all the determinations that I've been to, and I think it's appreciated by all First Nations people, when the federal court actually says, we are not giving you anything, we are recognising something that you have always held, that is something that really resonates with people. So, but anyway, agreement making is critical to the Act, and it's critical to the way native title is resolved, and it's going to be critical to the next phases of native title.
Will we turn to the next phases, the time available? So we're going to look forward now. We've been looking back. We're going to now look forward, because we're starting to see the first of the compensation judgments being delivered in our court, of course, building on the back of the High Court decision in Timber Creek. So we've now had decisions relating to the McArthur River project in the Northern Territory, in the Gudunji, Yanyuwa and Yanyuwa-Mara peoples, and we have also had the decision relating to the Solomon Iron Ore project with the Yinjibarndi people that we've already touched on. I might jump to you, Kingsley. I know it's taking you off the run sheet. I hope that's okay with you. But from our perspective, particularly in relation to cultural loss, the evidence of cultural loss is incredibly important to this part of decision-making going forward. Have you got any comments that you might make to assist us all in relation to making sure we secure that evidence going forward?
Yes, well, the area of compensation research, it represents a whole set of new challenges which aren't necessarily found so commonly in the straightforward applications made for the recognition of native title. Not least of which is the complexity of the legal environment, which of course is developing almost as we speak. So that the parties involved, from my observation, are perhaps at once reluctant to pursue a claim until the jurisprudence, as it were, settled down a bit. Some of that has been resolved in the recent decisions of MacArthur River and Injibandi. But secondly, of course, it is also a complicated area to research because you're asking people about loss. And it's not just loss that you lost, you know, some money or something like that. These are matters which are existential, in my view, to those people with whom I've worked. And doing that kind of research is difficult, and it's complex, and in some respects, it's dangerous for the people that you're talking to. Additionally, since we're talking about events which may have occurred sometime quite recently after 1975, we're talking about the people who were first impacted are now reaching an age which they're not going to be forever competent, able to give their evidence in a forthcoming claim. So the taking of early evidence in prospective compensation claims seems to me a really important way in which the federal court has seen fit to permit the taking of this evidence. And of course, I'm not a lawyer, so I don't understand the decisions that have been made, but I'm aware of a recent case in the Southwest Kimberley where the judge ruled that, yes, indeed, this was an important way to secure this evidence, and so it was heard. And I think that this is a very good example of how the native title law has been understood by the federal court as something which is rather special and needs to have a treatment which is commensurate with the cultural sensitivities and the particular difficulties that may be faced by all of those involved in hearing claims in relation to this Act.
I might follow up on the question, really invite both, first Michael, then Kevin, to comment just on this same topic, because it obviously is in some ways the next frontier for the court, the next frontier for claimants, the compensation claims are only to start. But any reflections that first Michael and then Kevin might have on thoughts about the impediments to compensation claims and the development of claims of these kinds?
Well, there was never any doubt that compensation was going to be the next big wave. I recall writing a paper in about 2002 where I said we'll sort out the rules over connection and recognition of native title. That took some time, and once we settled them, we then got the spike and we got the consent determinations, and then there was going always to be the compensation wave that would come. And I remember being in this court, I think, with Chief Justice Mortimer hearing the Timber Creek appeal in the federal court, and then it went on to the High Court, and then we get that. And now we've learned particularly about cultural harm. There's freehold, but there's cultural harm. And all the points that have been made by Kingsley about measuring that, it's not an obstacle, but it's a huge consideration to be made. We've got all the evidence taken in the native title cases where in proving connection, we've got the transcripts, we've got the evidence, we've probably got photos, we've got videos, but the issue there wasn't, you can infer it, but it wasn't, how do you feel about this? What harm have you suffered for what later has happened where there's been a future act, for example? Take the Injibandi case, former clients of mine, when I was at the bar, they feel so strongly about their country. So I think the lawyers, Michael, are going to be, and the anthropologists are going to be addressing this question. What are the, just like in the first phase, what are the important claims to be made? Who are the important people? How are we going to put this case? And we need to preserve this evidence as quickly as possible. It's not new to the law. I can remember as a young lawyer having to get preservation evidence I think, in what was probably going to turn out to be a fatal accidents case because someone was very ill and they were going to die, or witnesses are in that category. So it's a big issue. And there's going to be a lot of them. Kevin was telling me about the thousands of compensation cases in perspective. And for me, thinking as a judge used to have a lot to do with the case management of native title in the country, I think, how's the court going to do this? I think they're going to have to not just wait for individual claims to be made, but almost call for the claims to be made and try and work out how big it is and start to think about how we're going to deal with it. I still think, though, as in the Ward case that I was involved in, the Mirrong-Gadgeron case, which soon went to the High Court, connection after those points was never an issue. It was all about extinguishment. That case dealt with most of the issues. People were able to sit down and start working out consent determinations. But something like that might have to happen. No one's told me yet what of these cases, except MacArthur's not on appeal. I'm assuming Yindjibarndi might somehow or the other find its way to the High Court. But if it's going to happen, let's hope the High Court basically picks it up, takes it on and decides it quickly.
I'll just briefly touch upon the imperative, and I think Michael and Kingsley have already said it. We've got old people that are passing. The common lament is at native title determinations is that our elders are not here to enjoy the determination. It is a travesty if the system now actually says that our elders will not be around to enjoy the compensation of that loss. So that's from a very human level, but from an existential level, from an evidentiary point of view, it's the very witnesses that you need to actually prosecute these claims successfully. So there's a double limb there, and that's the imperative. The impediments really are the capacity and the capability of the system to deal with those realities. My maps before showed the layering of the workload, and so rep bodies and PBCs will need to navigate the storied priority work, and compensation will be in there. So how they will deal with that is going to be important. Some of the solutions rest with leveraging the very comprehensive archive that we have already. In the first phase of native title, we've got lots of transcript, we've got lots of affidavit, we've got lots of research. I think using that work in a structured way is important. We do need to get some strategic litigation going to get some jurisprudence that will inform the agreement making table as well. So there's a symbiotic relationship there, and so we do need to see that that strategic litigation come through. Yindjibarndi was one of them, and we'll have many coming through. That will actually inform the agreement making context that we're in. So there's a duality there, but the imperative, I think we've got to be driven by the imperative that old people are passing, and we need to preserve that evidence. We need to use creative ways, and the Chief Justice has done that. Justice Longbottom recently did that in a pre-claim preservation evidence process, and I just think we've got to, lots of tools in the toolbox when we've got to take out all the tools because the imperative is critical.
I think we're out of time, aren't we? And I know that members of the audience have a very important engagement that they need to get to, and I'm reluctant to keep you from the Governor. I think it might be, but it's been a great privilege to participate in this seminar, both celebrating the 50th anniversary of the court, but even more significantly reflecting on the court's native title jurisdiction. The reflections of former Chief Justice Michael Black concerning the manner in which the court adapted its procedures to accommodate the special requirements of native title cases were, I think, very powerful. We've been incredibly fortunate to hear from three people whose work has greatly impacted native title law and practice. From the very commencement of the Native Title Act. And I would invite you to join me in thanking our speakers today, Kevin Smith, Kingsley Palmer, and Michael Barker, for their very thoughtful contributions. Thank you. Thank you. Thank you very much.